morning. And for those of you watching at home, you'll notice the background is a little different today, and that is because we are in West Virginia's historic Independence Hall. And normally we come out and we hear the cases, we don't announce people, we don't have discussions, but today is just a little different. We're having our laws program where we have been working with the local students, and we want to recognize a few people who are with us today. Seated in the courtroom, I see the Honorable John Preston Bailey, Judge, United States District Court for the Northern District of West Virginia. I see the Honorable James P. Mazzone, our Circuit Judge. Judge Hummel is supposed to be here. I don't see him yet. Judge Cuomo is also supposed to be here. I see Judge Ferguson and Judge Joyce Ternenko, Brenda Miller, the Ohio Circuit Clerk, Glenn Elliott, the Mayor of the City of Wheeling, and Rose Humway, a retired magistrate. Judge Wilson. Judge Wilson is here too. Good morning. And so many others that I'm quite certain that I forgot and will be offended at that. So we also want to express our appreciation this morning to the various teachers who made this program possible, such as Ryan Stanton from Wheeling Park High School, Richard Marsh from Wheeling Park High School, Bill Brubaker, Lindsley School, Sean Decker, Central Catholic High School, Jamie Campbell, Central Catholic High School, and we had several volunteer attorneys who worked very hard. The students, I know that you got to meet them, got to work with them, and we appreciate them very much. Robert Fitzsimmons, Rocky Fitzsimmons, Clayton Fitzsimmons, Brent Weir, Mark Colantonio, Justin Wader, Donald Crescian, James Stoneking, and Sharon Potter. We thank all of you, and we thank our court staff who always work very hard to make this possible. Thanks for having us, and Madam Clerk, would you call the first case?
Yes. The first case for argument today, State of West Virginia versus Michael Blickenstaff, docket number 16-0666, an appeal from the Circuit Court of Jefferson County, West Virginia.
Chief Justice Lawfrey, honorable justices, good morning. May it please the court, my name is Dana Eddy, and I represent the interests of the petitioner-defendant Michael Blickenstaff in this proceeding. This court's opinions in the cases of State versus McCoy, State versus Edward Charles L. set clear boundaries on the use of expert witnesses in a criminal prosecution when it related to testimony regarding the victims. The concern of this court was that these expert witnesses should not, in the words of the court, improperly and prejudicially invade the province of the jury. And the court indicated that expert witnesses could do that in two ways. One, they could attest to the credibility of the witness. That is intended to be solely the function of the jury, not the function of an expert witness. So that was improper, would be improper for an expert witness. The second is to give an opinion as to the actual guilt of the defendant in the matter. Again, that is solely the province of the jury, not the province of an expert witness. Basically, what the expert witness in such a situation is to do is to give objective findings during their treatment of or counseling of the victim in the case. In this case, all those clear boundaries set by the court were crossed in derogation of this defendant's right to a fair trial. In this case, an expert witness, a social worker with a bachelor's degree, without ever having either interviewed or counseled the witness, gave opinions that, again in the words of this court, improperly and prejudicially invaded the province of the jury. In the particular circumstances of this court, the expert witness was indicated or was noticed as a witness to testify regarding the behaviors of victims of domestic violence. In the course of this social worker's testimony, however, what she ended up doing was, one, attesting to the credibility of the witness, and two, proffered an opinion regarding my client, Mr. Blickenstaff, that he was a probable killer, thus basically verifying her belief in the guilt of this defendant on these charges of kidnapping. Specifically, she was, again, this is a social worker who never met with this victim, never counseled this victim, never delivered services to this victim. Instead, the social worker sat essentially as an improper 13th juror in the courtroom and listened to
Upon
the...
which case are you relying to state your position that this was error in terms of the testimony, the expert testimony?
Both cases, Your Honor, both Edwards L. and State versus McCoy, because the boundaries, as I said, were clearly set and the boundaries were crossed. And again, as a 13th juror, this social worker sat there, listened to the testimony of the victim in the case, and then when called, gave a few comments about the general behaviors of somebody who is a victim of domestic abuse. And remember, the domestic violence charges in this case had already been dismissed.
What's the reversible error? What's reversible about that?
That is the impingement upon this client's constitutional right to a fair trial, due process under the 6th and 14th Amendments.
He didn't object.
In fact, there was a motion to eliminate filed, and pursuant to Rule 12, that preserved the
Very
objections.
generally, but there was not a specific objection raised later at the time of the testimony, correct?
In the motion, in the hearings on the motion to eliminate, the defense counsel made quite clear what his objections were to the testimony of this expert witness, even to the extent of complaining to the judge that the state had untimely disclosed the intent to use this expert witness in the case. So the use of the expert witness and the defendant's continuing objections to the use of this expert witness were clearly in the conscience of the judge at that point.
What was his specific objection at the pre-trial hearing or in his motion?
There were...
What was his specific objection, and then I'll read it to you.
There was a broad objection made to the fact that the expert witness, under the probative value prejudicial balance, would prejudice greatly the defendant's attempt to have a fair trial.
Well, but what was the specific objection that the judge had to rule on? I mean, the rule that you cited says that the objection has to be specific. Let me read what he said.
Yes, Your Honor.
The expert has never spoken to either the defendant or the victim. She's just going to speak in generalities. She has no idea. She's a fact witness. She has nothing factual to add about it. What is the legal objection as to the specifics for the judge to rule on, rather than just say, well, she's a fact witness?
Again, I believe the defense counsel made clear to the judge that he felt that the use of this expert witness would invade the province of the jury. That in fact, not only was she going to be a fact witness, but she was going to determine facts that should be left to the jury to determine.
Well, didn't this witness primarily testify regarding the behavior of the victim, not the defendant, in explaining that if she was a victim of domestic violence, the manner in which she acted would be consistent with that? That doesn't go to the ultimate issue.
I respectfully disagree, Your Honor. If, in fact, all the witness had testified to was the behaviors you might see with respect to generally victims of domestic violence, that would be one argument. That would be one discussion. A discussion we're not having, because what actually happened and what dominated the testimony of this particular witness was that the prosecutor asked her questions saying, did you hear the testimony of this witness regarding these facts? And then asked the expert witness to basically opine at that point that that in fact was valid behavior for a victim of domestic violence.
Well, the defendant was not on trial for a domestic violence count. He was
That
on
is
trial
correct.
for kidnapping.
That is correct. Which finally gets to the point that whatever the testimony was,
But you saying what happened at trial, but I justifying the objection.
Your Honor, again, in the motion...
The lawyer just sits there. How's the judge supposed to rule? They're supposed to take over the trial and start questioning the witnesses? And
Your Honor, again, I would fall back on these courts cases and on the Rule 12, which indicates that once the motion was made, the projection is preserved throughout the trial.
well, you're self-admitted. It was just a general objection. Oh, Judge, I think she hadn't talked to this person, and she'll just be a fact witness.
Well, it was general only because, in fairness to the defense counsel, at that point, the prosecutor had not completely or specifically disclosed what the testimony of the witness was going to be. In fact, as defense counsel pointed out, this witness had never even spoken, or this witness had never even spoken to the victim. So he was dealing in generalities because all he had was a complete lack of specifics about what this witness was going to testify to, except a general pattern, perhaps, of behaviors.
Why didn't you file a motion to compel and get that information and then make a specific objection?
At the time that it was filed, it was 2 days, I think it was during the pretrial stage, and trial was forthcoming. And I believe that defense counsel made an admirable effort to point out to the judge that the late filing of the supplemental disclosure, which made a reference to this lethality index for the first time, was untimely, made it impossible for him to truly understand or accurately prepare for what the expert witness was going to testify to and should be excluded.
Isn't your better claim for a writ of habeas corpus for ineffective assistance of counsel for the defense lawyers to be sitting in trial on his thumbs and never saying anything?
Again, Your Honor, I believe defense counsel under Rule 12 believed he had preserved the objections.
He may believe it, but what is the specific objection he preserved?
Your Honor, I believe that he preserved the objection that the prejudicial value of this witness greatly outweighed any probative value that it had. And as one justice already commented, Justice Davis, I believe, what was the probative value even of this testimony? This was a discrete charge, kidnapping, that had a discrete beginning and ending. And what did it matter whether this was a victim of domestic abuse or not? There was no need to fill in the elements because it was quite clear from her testimony, if believed by the jury, that there had been threats made, a weapon produced, restraint, and whatever. So all this proved to be, first of all, not even probative, but secondly, misleading to the jury because it was talking about a crime that wasn't even being prosecuted in the course of this trial.
His defense was consent.
In fact, there was no defense presented. The witness did not testify.
But didn't his lawyer argue that?
His witness argued inconsistency in the testimony of the witness based upon her statements to one, the Maryland troopers, and then to the West Virginia troopers.
How is it that you contend that this testimony violated the parameters that were set forth in Charles Edward L.?
2, in the context of the questions as asked by the prosecutor, it's undeniable that she was essentially bolstering the credibility of this witness. In other words, the prosecutor would say, in the course of the kidnapping, the witness testified this. Did you hear that? Yes. Is that consistent with someone who has been the victim of domestic abuse? Yes.
Well, did not Charles Edward L. permit testimony regarding the conduct of a child who's been abused, whether that would be consistent with the whole syndrome of child abuse victim?
In that case where there was a treater, somebody who had actually met with the child victim, counseled them, Edward Charles L. permitted that treater to testify to the fact that the conduct of the kids were consistent with victimization. But it was not asked in the context of the testimony of the kids at trial. And in fact, Edward Charles L. went on to say that what the treater could not do in that case is indicate, 1, that he believed the child, and 2, believed that it was the defendant that committed the act.
But neither of those two things happened here in your case.
Your Honor, I would
That's
submit...
why I think your reliance on Charles Edward L. is misplaced.
Well, we can argue about the first part, but let's talk about the second part, which is testifying as to the guilt of the defendant. In the course of questioning, the lethality index was raised. And in the course of explaining what the lethality index was, this social worker stated, based upon the testimony of the victim as I have heard it, based upon the facts as she has presented them, the lethality index would indicate that this defendant was in the probability range of being a killer of this particular victim. That was stated in front of the jury. They had her opinion that this defendant was in fact a potential probable killer, and that would make the issue of his guilt of the kidnapping almost certain within her opinion, and that was improper.
Was there objection made to the question?
I'm sorry?
Was there objection made?
There was not, Your Honor.
Well, judges can't just get involved and try the case for criminal defendants.
Nonetheless,
Our rule is you have to object or you waive it, because lawyers won't object, and then they'll spring it on somebody at appeal.
Your Honor, I understand your concern, but this is not a case where this was the first time the objection had been raised. The motion to eliminate had been filed. The defense counsel was relying upon the fact that he had a thorough discussion with the judge about his objections to the use of this witness. In fact, the judge made an offhand comment at the beginning of the trial that he understood the defense counsel had all these continuing objections. The defense counsel chose to remain silent during the course of the trial, but nonetheless had raised before the judge, had discussed with the judge, and I submit had implanted in the conscience of the judge the fact that he objected to the use of this witness for any purpose.
Do you have any additional arguments you'd like to cover?
Yes, Your Honor, there is the use of 404B evidence. The 404B evidence that was used in this case was the conviction of the defendant several years previous for an assault against the victim. The purported use of the evidence was to establish that the victim had reason to fear the defendant in this situation. That comes out of the cases where, in fact, from the appearance of the matter, one could say that consent was potentially an issue. And that type of use of 404B evidence is permitted to try to establish the lack of consent on the part of the victim. We don't have that use in this case. I think the state, when it began the trial, forgot the fact that the domestic battery counts had been dismissed for being past the statute of limitations, and that they were focusing solely on the kidnapping charges. With respect to the kidnapping charges, there was no need for any bolstering of the victim with respect to whether she feared the defendant or not. She testified to the presence of a weapon, she testified to the threats that had been made against her, and she testified to the restraint that was exercised upon her. The fact of a domestic violence conviction 2 years before added no probative value to the argument. And the problem we have is that we're not using just similar acts or wrongs that occurred in the past, much like we often use to prove motive or opportunity or pattern, but we used a conviction.
Now, the defendant below had a McGinnis hearing, and there was also a limiting instruction.
That is correct, Your Honor, but I would suggest that the prejudicial value of the fact of the conviction itself so outweighed the probative value that it was an abuse of discretion not to exclude it.
Well, how could we hold this abuse of discretion? The judge was sitting there in the McGinnis hearing and made credibility determinations, saw the people, and made this ruling. Now, you're wanting us to say that he abused his discretion just by reading some paper.
No, Your Honor, I want to point out, remember at the time of the 404B hearing, I think the domestic violence counts were still in the indictment and were still set to be tried at the case. But the judge engaged in the balancing analysis required by McGinnis and determined that the probative value outweighed the prejudice. But the only probative value of the conviction was to establish, perhaps, if necessary, that she was reasonable in her fear of the defendant. As the testimony came in on solely the charge of kidnapping once the trial started, that balance tipped so heavily toward prejudice because a conviction was put in front of this jury. This was a convicted felon sitting in front of them. And the fact that he had assaulted the victim 3 or 4 years before had nothing to do with this kidnapping, because all the elements were present in the victim's testimony. There was no need to supply a missing element, as occasionally we do under Rule 404B, in permitting those acts in to supply that missing element. So it was nothing more, it had no probative value, and it was highly prejudicial.
Was it not probative in demonstrating why she behaved the way she did on the date of the kidnapping?
That was not made an issue in the case. The only testimony was that of the victim. The defendant did not testify.
Did you all not argue? What was the defense argument at the conclusion?
The defense argument related to the credibility of the witness with respect to statements that difference in statements made to the various investigating officers.
So her credibility was the issue.
Credibility was an
Whether she was telling
issue.
the truth,
Yes.
and perhaps this testimony then was probative on demonstrating why she was in fear when he came, and when she had the opportunity to go out for a little while, didn't report it right away. Of course, that was before the knife was drawn and so forth.
The discrepancies related to the details of the crime itself. The fact that she had been assaulted 3 years before has no probative value regarding credibility on the issues of what happened during the actual crime. That is, from the time that he took her out of the car, put her on the other side, and started the course of the kidnapping. There was simply no probative value to this. But yet what the jury knew is that they had a convicted felon sitting in front of them. I submit that type of prejudice makes it impossible, when combined with the issues or the points made regarding the expert witness, made it impossible for this defendant to get a fair trial.
Well, doesn't the fact that she was abused previously, isn't it relevant because when they were at the gas station and he left, that she didn't run?
She testified.
Doesn't that show that she was predisposed to be fearful and didn't run when she had the chance?
She testified to the various reasons why she remained in the car, not the least of which was her child was still in the car as well. And she testified without any contradiction from the defense or any evidence to in any way raise credibility regarding those explanations. So this was mere bolstering, basically, to say that this guy beat her up 3 years before, he was convicted of it, he was put in jail, and because of that, you should know that when you decide whether, in fact, this kidnapping occurred as it was stated.
Mr. Eddy, let's see what the state has to say about this. You did a fine job.
Thank you, Your Honors.
May it please the Court, Mr. Chief Justice, my name is Robert Hogan. I am the Deputy Attorney General at the Appellate Division, and I have the privilege of arguing this case today, it having been previously briefed by the Jefferson County Prosecuting Attorney's Office. Many of my arguments have been sort of anticipated by your questions, but I'd like to step back and discuss the defense strategy in this case. It's crystallized in the closing argument that counsel gave at page 356 of the record, where counsel said, "This isn't the first time she's made some crazy accusation against my client." If you can distill the defense strategy into a single sentence, that, to me, that would be it. And so we step back and look at what the state's challenge was in this particular case.
When was that statement made?
Pardon me?
When was that statement made?
That statement was made in the closing arguments at page 356 of the appendix record. And so the state faced an interesting challenge here.
Maybe Mr. Eddy will get back up and say we had to make that argument after the evidence that you introduced during trial.
That was the theory of cross-examination throughout the victim's testimony in the case. It was a consistent theory presented by the defense throughout. And I believe it affected some of the issues we're going to talk about. The state had an interesting challenge here. The state had to explain to this jury why we had a victim, Nicole Mullins, who had reported facts consistent with kidnapping under West Virginia law, but who also had spent 2 or 3 days with the petitioner preceding the date of the event, and then spent another day or night with him thereafter. And the evidence at trial, and I know the court's familiar with these facts, but for the benefit of the audience, I'll share just a few of them. The evidence at trial was that on I believe it was Monday morning, that the petitioner took charge of the vehicle through the presentment of a knife, even though they were present at that time at a convenience store where there was a police officer present. And so these sorts of facts were things that
There was a police
state
officer
had to...
present at the convenience store when they went to get gas?
That's the evidence in
And
the
so
case.
what happened at the convenience store? Did he get out and go inside?
He did not.
What happened at the convenience store?
What happened is that as they reached that point, the petitioner got out of the car. He was in the passenger seat, walked to the driver's side, presented a knife, and told her to change seats, that he was taking control. And he did. And from that point, they embarked on.
Around the car, did she scoot over?
The evidence is not clear on that point.
Where
Your
was the
Honor.
policeman?
That's not clear either. But there is evidence that a
Well,
police
well,
officer was present.
Well, I mean, that's a pretty important, you're the one that just brought up that there was an officer present, and now you're saying you don't even know.
And the state has the burden of proof. I mean,
The-
you say that she spent the night with him that night,
True.
and all she had to do is sounds consensual to me, all she had to do is get out of the car and say, Mr. Policeman.
And that's the point of why the state needed to explain Ms. Mullen's conduct in this case through the expert testimony of Ms. Spriggs and through the 404B
Was there an
evidence.
objection made or a motion made that somebody with a social worker is not an expert in psychology and didn't have the qualifications to render these opinions as to her state of mind? Was there an objection made?
At page 284 of the record, Your Honor, when the state proffered at trial, Ms. Spriggs is an expert, petitioner had no objection. And so continued to testify regarding her opinions thereafter, again without objection.
Did the defendant's lawyer do anything?
It's apparent,
Everybody's entitled to a fair trial. You might
Certainly.
think he's guilty.
certainly. The defense theory of the case was that this is a case of fabrication, that this was a case of embellishment. And so in the case of the expert testimony, the defense counsel strategy was not to object, because to do so would highlight that evidence even further.
Well, is a social worker with a BA degree, AB degree, qualified to give testimony in the field of psychiatry and psychology?
She didn't give, she was qualified to give opinions regarding characteristics of domestic
Well, it really
abuse.
doesn't matter. If they moved to qualify her as an expert, there was no objection to her being qualified as an expert. Whether or not she had the qualifications is irrelevant if everybody conceded that she was an expert. That's the state of the case that we have.
Agreed.
What about the
Attorney
motion?
General, let me ask this. Couldn't it, to the contrary, say that the error is so plain, so egregious, that we can take it up under the plain error doctrine when we see somebody really getting screwed and the lawyer's sitting there on their thumbs?
No.
We can't take it under the clear error doctrine.
The evidence in this case was sufficient to warrant.
We can't or we shouldn't? What's
shouldn't.
the answer to Justice Ketchum's question?
You should not. And if I'd like to address each of these issues separately, so that we can narrow down on where they fit in under the court's standard of review. If we look first,
Just one more thing on the objection, though. Counsel relied on the motion in limine to suggest that objection had been properly made.
the motion in limine was filed on March 21st, about 10 days before this trial began. At that point in time, in fairness to defense counsel, he did not have a summary of the proposed opinions,
Well, in fairness to defense counsel, why would he make the motion without getting one?
because he's a good defense counsel and he's going to file a motion to preserve the record. In this instance, it was a very general form
A
objection.
good defense counsel first worries about trying to get to marshal the facts and find his counsel not guilty.
I don't disagree.
And you can't do it without the facts, which he didn't get.
True.
So there's two kinds of defense counselors. Ones that lay in wait and ambush the state, and the other kind that prepare and try and beat them at trial.
I understand.
I mean, how would you like your kids to defend somebody if they were on trial and witness while he just sits on his thumbs?
Your Honor, most of us have tried cases, probably all of us have tried cases, and it's easy on a cold record to look back and second-guess the decisions of counsel. That's why we don't address ineffective assistance of counsel in direct appeals.
Well, we can. It's just not the preferred.
It's not the preferred.
And there's a difference between looking at the strategy and decisions of counsel and counsel doing nothing.
This counsel didn't do nothing, Your Honor.
Well, he didn't get these the information he needed before he filed a motion in limine, and his motion in limine is less than pure generalities.
That's true. That's true. All of the objections that were posed to the expert testimony were presented in generalities, and that's why the evidence of the lethality index, the evidence of this various stream of questions that we see printed and with various words highlighted in bold in the briefs, it's why those objections were not preserved.
Well, now, the other side cites Charles Edward L. supporting their position. I think Charles Edward L. is more supportive of the state's position, but it was in the context of a child abuse victim. Do you have any cases that you can cite where the court has held that expert testimony on the profile of a domestic violence victim may be admissible?
None apart from the McCoy and Edward Charles L. Cases that are reflected in the briefs, Your Honor. But there's a difference between vouching. What those cases really stand for is there's a difference between vouching the credibility of a witness, or in particular the victim, and corroborating it. And that's what the expert in this case did. Her testimony helped corroborate it. Her testimony was presented in an effort to explain why the victim conducted herself as she did, to explain the types of behaviors that victims of domestic violence exhibit, and how the actual testimony of the victim in this case was consistent with what this witness had observed in her personal experience as well as in her training.
Well, absent any additional questions from members of the court, we understand your position, and let's see if Mr. Eddy has a brief response.
Thank you, Your Honor.
Actually, the court has covered in its comments many of the rejoinders I would have made, except I do want to focus on one point that was made. To the extent it's the determination of this court that there should have been objection, I would implore the court, considering that this is a defendant who is facing life in prison without mercy, to consider the plain error doctrine. In my mind, there is no question but substantial constitutional rights were involved. This is an issue of a fair trial, and I submit that it cannot be fair when, in fact, a social worker with a bachelor's degree is allowed to come in and declare the defendant a probable killer.
Mr. Eddy, does your brief research and set forth the plain error doctrine?
It did not, Your Honor.
Here we go again. You want us to raise the plain error doctrine, you guys don't even raise it.
Well, maybe you could talk to other people into it, but I do not see this as a plain error case.
Yes,
This
Your
you
Honor.
may bring on the habeas and explore further, possibly.
I would point out, though, that one prong of the plain error doctrine is to basically protect or assure the fairness, integrity, or public reputation of the judicial proceeding. I don't know that we want social workers throughout the state coming in and providing their opinions in cases of prosecuting defendants, bringing in their opinions regarding the veracity of the witnesses who are testifying.
That's not what she did.
Is it
It is, Your Honor.
Is it plain error not to put it in your brief and research it for the court?
It would have been plain
There's
error.
some old man up here bringing it up?
It was, Your Honor. It was an oversight. It was.
Is it plain error?
I'm not sure so
Probably
plain.
not in your case, no.
Thank you.
Thank you. The case will be submitted.
The second case for argument today, Hanson versus Keeling, docket number 16-0799, an appeal from the Circuit Court of Kanawha County, West Virginia.
Good morning.
Good morning.
May it please the court, justices, and Chief Justice Lawford. I read the article in the local paper here about the program that all these students are here for, and the importance of that program and showing them what the judicial branch of government does and what its impact is on their lives. And there can be no more significant impact than for the judicial branch to be the protector of the rights of all of our litigants in this state to a fair trial and to equal access to justice. The trial court in our case did not protect those rights and impeded those rights as to appellant Kevin Hanson. And it is this court's opportunity now to fix that. We had a very straightforward case, and it was an auto accident case. We agreed upon and stipulated to liability. We stipulated to medical expenses of about $70,000. The only issues for our jury to consider were pain and suffering and lost wages. Ultimately, they awarded $100,000 roughly in lost wages and $375,000 in pain and suffering, which was an excessive verdict. It was occasioned upon the court's error in two areas primarily.
You think the verdict for these injuries was excessive?
Absolutely.
Wasn't even 2 times the damages.
$375,000 when compared to the $70,000 in medical expenses was...
You know, I understand that your argument is that the judge took over the trial on behalf of the plaintiff.
Indeed.
But it seems to me, based upon the extent of the damages in this case and the low verdict, the judge didn't do a very good job convincing the jury.
It appeared that he tried his best, Your Honor. And the jury
So
ultimately...
that's your first issue. So what's your response to that?
Sure. First and foremost, the plaintiff's injuries in this case were a blown-out ACL and MCL, both of which were taken care of by surgeries that both resulted in successful recoveries. A month out from treatment of both of those surgeries, he says to his doctors for every visit,
Did the defense
no
counsel object or have a sidebar and go up to the judge and say, hey, judge, you're taking over this case. You know, I want a continuing objection to your line of questioning?
Your Honor, I dealt with that actually on pretrial motions.
Answer my question.
Yes, even before trial. There was a motion by the plaintiff to be permitted to call the surveillance private investigator retained by the defendant.
No. That's not my question. My question to you is, when the judge took over the questioning during the trial, did defense counsel make an objection, a continuing objection to the judge's questioning, have a sidebar in any manner?
No, Your Honor. I can explain why.
Well, I want to hear it.
Sure. The very first objection that was made at trial was in plaintiff's opening, when plaintiff went into great detail about liability and about how this accident happened and how atrocious the defendant's conduct was. I objected to that.
Were you trial counsel?
I was, Your Honor. And the trial court responded to my objection in that to, number one, do not approach the bench. You make your objections from there. I made my objection from there. He then denied it.
So your trial strategy was not to make any more objections during the trial because that might cause pause to the jury?
My concern was, yes, Your Honor.
So that was your trial strategy?
That's correct. My decision was that this judge is very clearly already not in the middle and impartial where he's supposed to be. He's on the plaintiff's side, and he's acting as an advocate for the plaintiff.
So you chose not to object, and you sat on your rights.
You can't have it both ways, Mr. Mincer. I mean, you were here for the first argument.
That's correct. The plain error doctrine does apply in this case, and this court has already looked at this very issue in the case of State v. Thompson.
Yeah, but the defense lawyer was on his feet every time the judge took over.
In the state,
I think in this case, how many questions did he ask? 200 or 300?
he asked 74 questions in a 2-day trial.
And no objection from the defense lawyer.
That's
And
correct.
in the Thompson case, how many questions did the trial judge ask?
I don't know. I know in the Nutter case that you all considered last year was 300 questions in the span of 8 days of trial.
Well, but the defense lawyer was on his feet every time.
That's correct, and we all know what happened when he did that.
Yeah, he won. We reversed it.
And the judge
Because he
ultimately,
stood up and objected.
and the judge ultimately got more and more egregious every single time he objected, first of all. Secondly, the judge grabbed
Well,
his trial
in
notes.
your case, you want us to smack the hands of the judge when it was your responsibility to make the objection, not the trial judge.
I don't know what is achieved by making an objection to a trial judge who then is going to decide on that objection.
It's making your record so that can be examined.
At the cost, however, of making it even more clear to this jury that that judge is on the plaintiff's side of the bar.
Maybe or maybe not. An objection also might signal to the jury, hey, this trial judge is out of line. The trial judge is taking over, and that's not fair. It could also be the flip of what you're saying.
You have a very tough row to hoe on this issue. You can respond, or I would move on to your second issue.
Sure. If I can respond briefly, this court considered that in State v. Thompson, and there was not a lawyer who objected. There was no objection raised in State v. Thompson, and this court said this issue of a judge violating Rule 614 of the Rules of Evidence.
What was the year on State versus Thompson, the criminal case?
It was a 2007 case.
2007. In 2016, we decided a case with this very judge that asked over 200 questions in 2016 where the defense lawyer objected every time or had continuing objections and reversed that judge.
That is correct.
Now, you're wanting us to reverse him when he doesn't think he's doing anything wrong. Nobody's complaining.
In the State v. Thompson case, this court said this is such a fundamental integrity and fairness issue to our justice
Yes,
system.
but to follow
that we
up
will
with what
reverse.
Justice Ketchum is saying, we have a more recent case where the defense lawyer continually objected, and we reversed it and said that's the job of the defense lawyer.
And
So-
State versus Thomas was a criminal case. We look at them harder if somebody's going to be put in a cage. This is just money.
There is no distinction between criminal and civil cases
Really.
when it concerns fairness and integrity of the court and equal access to justice and a fair trial for litigants.
There's no distinction in that, okay, well, we'll just pass a law that these poor judges, nobody's got to object anymore. Just sit there and slip-shuck the judge and come up on appeal.
There's a difference, Your Honor, between objecting to other counsel's actions and objecting to the court's actions.
I don't know of any distinction.
This court found in State v. Thompson that even without objection, the crossing of the line set forth in Rule 614 of the Rules of Evidence is an issue of fundamental fairness, and that it will reverse even without objection when the judge has violated his right or his duty of
I don't
impartiality.
think we have a syllabus point in any of our opinions that says that there's a different standard in terms of objecting because of the conduct of a trial judge and objecting because of the conduct of your opponent. And
That-
I would, can you cite any? Can
I
you
believe
cite-
that exact point was addressed in the State v. Thompson
That was a
case.
syllabus point?
I don't know that it was a syllabus point, Your Honor.
Well, I can tell you it wasn't addressed in State versus Nutter. Nutter said you got to object.
With all due respect, Nutter doesn't say you have to object. It says when you object, we will overturn. It doesn't say the opposite of that, which is without objection, we will not consider it.
You know,
So we
this,
got to write our sentences two ways now.
Or follow the court's precedents in that State v. Thompson case.
well, we're well aware of the court's precedents, and you're spending an awful lot of time on an issue that the court, I think, is sending a pretty good signal that that is not your strongest argument. And you're running out of time if you want to discuss your second issue.
I appreciate that. The second issue is this. The court permitted appellee's counsel to call appellant's retained private investigator who conducted surveillance as a witness at trial. And not only did that, but ordered him to come back to West Virginia to testify at trial when he was in Florida, exceeding the scope of the court's jurisdiction anyway.
Was that a sanction or was that an evidentiary ruling?
According to the court, it was a sanction for a delay in disclosure of photographs and video from surveillance.
Are you sure? I thought according to the transcript it was an evidentiary rule.
The way that it was even brought to the court's attention was by means of a motion for sanctions that was filed before trial by
Well,
counsel for appellate.
the court said, I said on the record Friday that my inclination that the respondent's motion to use him, the investigator, is granted, and I note the petitioner's objection and exception to that. That's not a hard ruling to make. Now I want to get to the issue of sanctions.
Okay. If you look at the court's order on not only the motion for sanctions, but the renewed motion for sanctions after trial, the court made clear that as an additional sanction, it would award appellee the cost of service of process upon that private investigation.
Well, doesn't the trial court have the authority under our rules to sanction when the scheduling order or the discovery plan is violated?
I certainly agree, and this court said in McDougall v. McCammon that there is an appropriate sanction for that, which is if there's a delay or an absence or a failure to even disclose the existence of surveillance videos or photographs, the sanction is to not allow the party that had that surveillance done to use that evidence at trial, or to continue the trial so that the plaintiff in the case could react to it.
Did you ask for a continuance?
I did not, Your Honor. I asked for the court to not permit appellee to call that surveillance private investigator as
Because the
witness at trial.
surveillance didn't help you.
It didn't, and that's why I ultimately provided it to opposing counsel and said, I'm not going to use this at trial. I will object if you do.
So if you
and it's work
provide
product.
it, which goes to my next question, you voluntarily turned over the surveillance, correct?
I did.
And now you argue that it's privileged?
There's two different issues there. One is me turning it over while maintaining my objection, but more importantly, the second issue is admissibility of calling that witness at trial and the purpose for which he was called at trial. Clearly, it was not because there was some probative value in those videos or photographs, because appellee did not even put in a single photograph or video. Instead, only asking that private investigator, who retained you? How much did he pay you? What did you do as part of surveillance? You took this photograph of his grandkids in the front yard in public, didn't you? You took this photograph of my receptionist going to the car and putting money in the meter. And you got rid of photographs that were not in focus or otherwise good pictures. Why would you do all of those things? And you were retained on behalf of Kevin Hanson, appellant in this case. Plaintiff's counsel then amplified that prejudice, which is what that is. It's clearly marked to induce prejudice in the jury's mind, and not for any probative value as to what plaintiff's limitations were on his knee following surgery.
Well, that's why you hired the expert, isn't it?
Surveillance is one of two tools that a defense lawyer has to test the veracity of plaintiff's claims about limitations after an injury. Right? The penalty for using a person to do surveillance and having the evidence come back inconclusive is not, well, now the other side gets to call your witness and use it as prejudice against you.
I don't think that was the issue at all. The issue was the fact that you had the documents and you were supposed to turn them over in a certain period of time, and you did not do that.
There was a delay of about 10 weeks.
10 weeks.
That's right. In the McDougall versus McCammon case, the defense lawyers in that case did not ever make the plaintiff aware or plaintiff's counsel aware of the existence of photographs and video. Instead, they...
Why did you wait 10 weeks?
It was... what happened ultimately was the discovery request came in with the complaint when it was filed. At the time it was answered truthfully that there were no videos or photographs. When the videos and photographs came in, I had forgotten about that discovery request.
Don't you have a continuing duty to supplement your discovery under our rules?
Indeed. And the sanction for a failure to do that is to not allow me to use those videos or photographs at trial.
Do you have any authority that the video surveillance or picture surveillance of an investigator or a lawyer is part of the work product document? Do we have any cases on it?
McDougall v. McCammon actually addressed that and said it's not clear that that is or is not work product. Again, we're talking about discovery and disclosure, however, we're not talking about admissibility. McDougal,
So first, don't we, in light of McDougal, that was my point, don't we have to make a determination first of all, whether or not it was work product? And if it wasn't work product, then the trial court didn't err.
this court in McDougal v. McCammon actually never reached the point of answering that question of whether it was or was not work product.
In McDougal, the defense lawyer did not voluntarily turn over the evidence, correct?
That is correct.
That's not the factual scenario we have here.
That is worse. That is worse than producing it with some delay, clearly. And even in that worst scenario where it was never turned over, the sanction was, okay, you who hired that surveillance private investigator cannot use that evidence at trial. It was not the far harsher penalty here, which was to allow opposing counsel to use it to prejudice.
But had you not already introduced it?
No, I had not.
Okay, didn't you use it on some cross-examination?
No, I addressed it with cross-examination of the same witness who appellee had called at trial, my private investigator.
You're saying I turned over the evidence, but I didn't waive it because I included an express statement that I'm not waiving this is work product.
I maintained those objections.
And they have to show a substantial need in order to utilize this.
I maintained all of those objections. However, the issue still goes to discovery and disclosure and not to admissibility of the evidence. Plaintiff's counsel said in closing argument to the jury, instead of taking responsibility for this accident and paying this man due compensation, they hired this sleazy private investigator to lurk around in the bushes. That's not taking responsibility. Make them take responsibility.
Was there an objection?
There was an objection made prior to trial.
No. When the person said it in closing, did you object and have a judge say you're strike and admonish the lawyer?
I did not.
And that's not one of your issues on appeal.
The use of surveillance
The use
for
of
prejudicial
surveillance is, but the
effect.
improper closing argument isn't.
No, it goes to the fact of why this issue was even used by opposing counsel at trial, which was to cause this prejudice. Under 403, it's clear that it was substantially prejudicial and that prejudice substantially outweighed any probative value because it had no probative value.
All right, Mr. Minister, we understand your argument, and let's hear from the other side.
Thank you.
Thank you.
Good morning, Mr. Chief Justice, members of the court. I'm Ben Salango, and I represent the appellee, Larry Keeling. May it please the court, if I may address first the issue with respect to the judge's questions, just briefly, and then I want to focus, if I may, on the private investigator.
Now, Mr. Salango, did you not listen to what the chief said earlier in this argument?
I heard it loud and clear, Your Honor.
Okay, well, I wouldn't spend a lot of time on the first argument
I
if you're going
certainly
to listen
won't.
to the chief.
But I do have one question about that. Could you address how it is fair for a circuit judge to continually, to characterize it fairly, questionably, get involved in a trial on behalf of one side or the other when that judge has previously been admonished for that conduct in the past?
Well, and that's one thing that I wanted to point out. You know, when they filed their motion for new trial in this case, they specifically said in their motion that the judge's questions probably didn't affect the outcome, and the judge's comments and questions may not have violated Rule 614. And that was in June of 2016. In November of 16, this court issued its opinion in Nutter, and all of a sudden the argument changes when they filed their petition for appeal. It was opportunistic.
Well, these questions weren't anywhere near, and they weren't, the ones I saw at least, were not of they were not of a partial nature. Weren't they fairly impartial?
No, not at all. They were absolutely impartial. And if you look at the questions that he asked, the witness could have answered them either way. And so, for instance, he asked about whether the plaintiff could do the job with bad knees.
Now,
Well,
I
that was
read
the
the entire
defense's argument.
transcript. I can get into some of the questions if you want to get down that road too far.
Well, I certainly don't want to go down the road. But I think
And
there's...
when you read the transcript, you can get the judge's tone. You know,
Well, and that's why you need to make the objection, Your Honor. And if they had objected to question 1, perhaps there wouldn't have been 73 more. But there was 60 years of trial experience sitting at that defense table, and that was a strategy call by them to not object.
Well, you can sit there and you can hope that you get a favorable verdict, and if you don't, you can come up here on appeal.
Which they did not only on that issue, Your Honor, but they also did that in the private investigator issue.
All right, so issue 2, let's go into that.
Sorry, Chief, I just have that one question.
Oh, did he answer your question?
Yes, absolutely.
Okay.
Well, if surveillance is not part of the work product doctrine, there's no error.
That's correct, and it's not part of the work product.
What authority do you have? Have you cited in your brief, and look at your brief and tell me what authority you cited that surveillance videos and pictures are part of the work product doctrine?
The closest case that this court has issued with respect to that specific topic is the McDougall case where I think it was Professor Cleckley indicated that it's not work product, but even if it was harmless error. And so then he even, in a footnote...
That's the whole point. I mean, Professor Cleckley wrote the book.
Yes, he did.
He says it's not work product. If this is not work product, no error.
It's not work product, and let me address just a couple of other points along those lines.
So you concede it's not work product?
I don't think it was work product, and it was voluntarily given to me.
Well, if it's not work product, why can't they put the surveillance man on the stand and go over the pictures with
They
him?
could have.
They can.
They chose not to. That, again, was trial strategy on their part.
It didn't
What they-
matter.
Oh, you put them on.
I put them on, absolutely.
Well, so you're saying because you put him on that it's no error because it's not part of the work product doctrine?
It's not my work, it wasn't my work product.
Okay, I'm sorry.
And I did not learn. Keep in mind, for 6 months, not 10 weeks, for 6 months, they denied that this even existed. They denied there was surveillance at all. These photographs were taken in November of 2015 when they responded to discovery, and the reason that Judge Kaufman sanctioned them is because in December of 2015, a month afterwards, after they had already started taking pictures, they denied it even existed. And so the judge sanctioned it for them. Where is that in the record? In the ruling, the court order at page, let's see here, 1904 in the record. And it's also in the transcript, Your Honor.
What is that? Was that an oral statement at a hearing? Was that an answer to an interrogatory? What was that?
The sanction of defense counsel for hiding this from me,
No, their denial that it even existed.
it's in their responses to interrogatories. And the court notes that in its order. I asked them, did you conduct surveillance? The answer was no.
All right.
But there were.
Does he? Okay. That's what I'm trying to get. Does the evidence show that they were conducting surveillance before they answered that interrogatory?
Without a doubt. They were conducting They hired the investigator before they answered the discovery. They took photos. They tailed my client. All of that was done before they answered discovery.
And then said they weren't surveilling? Under
And,
oath?
and failed to supplement for 6 months. Yes, sir. That's absolutely accurate. That's in the motions. That's in the order. That's why they were sanctioned.
And so, under our Rule 26, the court had every bit of authority to sanction such conduct.
Absolutely. And the sanction was appropriate. Now, the court even went beyond that. The court said, I'm not going even if I don't deal with it as a sanction, I think this investigator is a fact witness. What he learned by watching the plaintiff, it showed that the plaintiff was limping. It showed that the plaintiff was favoring his injured leg. Those things, then, I could call the investigator as a fact witness. And despite their brief that indicated that I introduced video surveillance, I did not. They did. They introduced it, Your Honor. I know you asked that question.
That's what I was thinking. But
At page 286 of the trial transcript, they introduced the video, not me. They also say that I introduced the report.
Was that on cross?
It was on cross.
So you'd already introduced the pictures and they crossed to introduce the video?
I introduced 3 photographs, is all I introduced. I never introduced the report, despite their assertions to the contrary. They say that I introduced it, I did not. I never introduced the video. I called him as a fact witness to tell the jury what he saw. And thankfully I did, because what he saw, and the reason why they didn't tell me about him until the day before trial, his testimony was terrible for them. It was terrible. He said, this client was severely injured. You can tell he favors his right leg, he favors his right knee. This wasn't a case where they got the investigator's report and they accidentally put it in the file and forgot about it.
Oh, they didn't want to show it.
They didn't want me to know
give
about
it
it.
up because
And
it
not
didn't
only that, Your
support
Honor,
their position.
not only that, they didn't want my client to know that he was being tailed. They didn't want him, and so if they had told me back in December when they answered the discovery, yes, we're surveilling your client, maybe they wouldn't have been able to tell him anymore. So they said he's not being surveilled, and they continued to follow him for months and months and months. And only until May, now they say it's a 2-day trial, it was actually a 4-day trial. We started on Friday, we ended on Wednesday. Then the day before a 4-day trial, they hand deliver it to my office. Oh, here you go. And by the way, we're not using it, so you can't use it.
What did they do the day before the trial?
Gave me the report of the investigator, finally conceded that it existed, gave me the report, the video, and the photographs. And when I opened,
Well, why do you do that if it's work product?
Well,
They
and
have to
that's-
give it to you if it's work product.
you're right. If they truly believed it was work product, they should not have given it to me. They should have shot it.
Did they file a protective order saying it was work product?
Did not, Your Honor. They said in their objection, now first they denied it existed. Then when they finally admitted it existed, they gave it to me with an objection. Objection, this is work product. We're not using it, you're not allowed to use it. And so that's when I asked the court, because then I had no opportunity to take this guy's deposition. I asked them to arrange his deposition, and you know what the response was? Oh, he's in Florida. You can't. He's in Florida, conveniently in Florida. And so the judge said, you know what, get him back here. And so we had 2 hearings on it. We had a hearing the morning of voir dire, right after the voir dire. And then we had a hearing before opening statements. And the judge said,
So
look,
defense counsel had every opportunity to file a protective order.
absolutely, and he did not. And importantly, the only thing the judge ruled, the only thing the judge said was, you can call this private investigator as a fact witness. That was it. He didn't say then that the defense counsel didn't have to object to any of the questions. So everything that you're hearing now, these things that I asked that are so terrible, they never objected to. Not a single
Well,
objection.
That's not an assignment of error.
Right. They kind of mixed that in there, saying that I called him sleazy, and I did in my closing argument. They mixed that in there, but there was no objection to it. There were no objection to the questions I asked, no objection to my closing.
What's wrong with calling somebody sleazy?
Nothing, Your Honor, if the shoe fits. Nothing.
Argument, you have a little bit of leeway.
I think so.
It doesn't have to be academic.
I agree with you, 100%.
All right, let's hear from the other side.
Thank
did a
you,
fine
Your
job. Brief response, but I want you to address specifically the last part of the argument that basically said that you were withholding this or lying about this prior to when you answered the interrogatories.
If you look at the interrogatories and the initial set of discovery, that is the issue of this issue right now, the focus of this issue right now, the question was not, did you conduct surveillance? The question was, do you have videos? It was not even that. It was a request for production that said, produce any photographs or videos you have from surveillance. It was answered on...
Produce any videos or photographs you have from surveillance.
Exactly.
And you, prior to that, getting that request for production, you were conducting surveillance.
The investigator had been hired to do surveillance.
Had he surveyed?
Had he surveilled, he had
Didn't
figured out
surveil
where the
prior
house
to
was.
that request for production. Now, you detailed what the question was. What was your answer?
On December 4th, I answered that and
What
said,
did it say?
none. We have no photographs, we have no video, which is absolutely true.
Well, it asks in surveillance, are you saying your surveiller did not have any video or photographs at that time?
To my knowledge, he did not.
But
I got
did you call
photo.
him and ask? I mean, it's fair when you get discovery to if you have a surveiller to call him and see. Did you call him to say?
I did not.
Just said, no, we don't have it.
I said, no, we don't have it. I received it.
When you had hired a surveyor, a surveillance investigator, and he's out surveilling this man, you didn't contact him to see if he had it.
That is correct.
Nor did you object at that time under the work product doctrine, you just said no.
No, I did actually object on work product doctrine as well.
Okay.
But ultimately, we got those photographs March 2nd or something like that. The photographs and videos of the plaintiff and him walking and his abilities, those were taken on February 13th and 14th, or 12th, 13th, and 14th. Ultimately, they were turned over on May 12th. Even if it is work product, we still do have an issue here about error, because it's error under Rule 403 to admit highly prejudicial evidence.
Did you file a protective order?
No, I asserted an objection that the court said was noted and preserved for the record.
I don't see how you were prejudiced, because the jury verdict with regard to these injuries was meager.
Not in appellant's opinion, Your Honor.
Not in who?
Appellant's opinion.
Well, you mean the defendants?
Yes,
Well, the defendant would never agree to that.
sure. I would agree. We believe it was an excessive verdict. We believe it was brought about by the court's conduct. And we believe it's an issue of fundamental fairness and integrity of the judicial branch, and that you all have the ability to fix that under the plain error doctrine.
Man, I agree with you on Judge asking all those questions, but boy, when you answer no and you hired an investigator and he's out surveilling and you say no without doing what the rules require to make an inquiry, and you just say no, that's not, is that truthful?
It was truthful at the time made. It was, I had a duty to supplement, no question, and there was a delay.
But you don't think you had a duty before you answered a question on an interrogatory? You would look at that from a technical standpoint and say, well, I don't have them in my hands, so therefore, and I mean, you hired somebody to go out and do this, and you don't feel that you had a duty to check with that person.
To my understanding at the time, he had not even been out to the house.
Well, you
at that
said you
point.
didn't call him.
You're right. I did not call him specifically about that discovery request.
Well, but under the rules, under Rule 26 to whatever, you have a duty to inquire, don't you? You'll agree with me on that, and you didn't inquire.
What kind of message do you think it would send to the trial bar in this state if we said there was no error, that you had no duty to supplement, and, you know, you answer an interrogatory as a member of the bar and answer the question no?
First off, I fully agree that I had a duty to supplement that and that there was a delay in doing so. The issue is, what's the appropriate sanction for that? And this court said in McDougall v. McCammon, it is, I can't use it. The court did not say the other side gets to use it, gets to call him as a witness. We are going to ignore the tenets of Rules 401, 402, and 403. There's no question he was intentionally called for the purpose of prejudice and instilling prejudice, and not for some probative value. There wasn't a single photograph or video introduced by the
Is Mr.
plaintiff.
Solano wrong when he says that the court permitted him to call the witness as a fact witness?
The court made clear he was a fact witness and not an expert witness.
Okay.
For opinion testimony.
So he could testify to the fact that the plaintiff was severely injured. So why is that prejudicial?
He doesn't have the medical qualifications to know whether the plaintiff was
You
severely
don't need
injured.
a medical degree to be able to testify that somebody's limping horribly.
Well, unless you know what their pre-accident walk gait was, you don't have a foundation for testifying that he's limping anyway.
That's ridiculous.
The evidence would...
That's terrible.
The evidence would...
I've been slip-shucked all my life and never complained, but you got to know what he walked like when he was a kid or a year before.
We understand your argument. This case will be submitted.
Thank you.
Yeah. No, we need to push my seat back. Okay, thank you.
Hang on, I'm going to move my seat.
Here you go, Mark.
No, I'll move back. I'm good. Thank you.
Thank you.
talk softly. Unless you're objecting.
I am. Far left is where I belong.
That was interesting. Did a nice job.
Sure. Sure. All right.
Working on the Thompson case.
I don't think so. Not myself.
I think Gordon.
Could very well be. You know, I assign the darn things out. And a lot of times the names stick in my mind and I can remember where they went, but that one, for whatever reason, doesn't.
Well, I'm back on that one with Scott's departure. I started really kind of wish we could work out a plan out.
Yeah. I mean, what's the background of the case?
Well, the horrible accident, infants killed, 2 individuals.
Testing. I don't think they're on. All right, if I could have your attention,
The
please.
worst part is the judges not replacing.
Thank you all for your silence. That was very much appreciated today. What we're going to do now, because as you've been told at least a dozen times, these are real cases that the justices are going to have to decide and write an opinion on, you cannot discuss the case with the justices, okay? They are prohibited under the judicial canons from discussing any case that is before them with anyone, not only with the litigants or their attorneys, okay? So please think of something to talk about with them at